Hello, everyone. Good to be here with you, and we're here to talk about long-term disability law. I'm a lawyer. I practice long-term disability law along with my team here, and we have quite a few lawyers on staff. And one thing that I'd like to tell people ahead of this Q&A is that I used to work for insurance companies many, many years ago, and so I worked on the other side. And of course, for the last 17, 18 years, I've been helping people who have been injured, people who have been struggling with their insurance disputes, short-term, long-term disability matters. And so we do these kinds of Q&As, Facebook Lives, and of course, our radio and TV shows. And we try to educate the public and level the playing field between you and the insurance company. And this perhaps may not be something that is applicable to you right now, but maybe you know somebody who may need this information. So just to start, I want to talk about something that has been really important to talk about, something that insurance companies really focus on in a negative way, in my opinion, in my experience, which is mental health claims. And we've seen this before COVID as well. People who needed to go off on short-term and long-term disability leave, and insurance companies have either not believed the individuals who have been saying that they're suffering from anxiety or depression or phobias or whatever the issue is, or simply rejecting those claims outright, or even worse, in my opinion, is approving them and then subsequently saying it's not that bad, you can go back to work. And so I've seen a lot of this. I've seen this obviously during COVID, post-COVID, and of course now with the tariffs and everything that's happening in the world. This is something that we see quite often now with people having difficulty with insurance companies. So let's talk about mental health disability claims, and let's dispel some of the myths. Number one, if you are suffering from a mental health issue, and again, it can be depression, it can be anxiety, it can be a phobia, it can be any number of things. There's just a myriad of conditions that you may be experiencing. The symptoms are what count. If you have a symptom or set of symptoms that disable you from working, disable you from performing the essential tasks of your own occupation, well, then you should be getting short-term and or long-term disability. And I say and or because some people have access to short-term disability, some people do not. Some people have long-term disability benefits or access to those through their work health benefits. Some people have coverage privately. They have a private policy that they've purchased, which I tell people, if you don't have that kind of coverage through work, you should be speaking with a broker or just Googling to see what's out there in terms of coverages that you may be able to get, because there may come a time where you may require long-term disability, shortened disability, and the insurance company is going to do everything it can, obviously, to reject your claim or to try not to approve your claim or to pay you as little as possible. Okay, before I go on to my points, I have a few questions here. One from Peter. How long does an LTD insurer have to respond to an application? I applied in November, provide all the documentation, multiple assessments, clinical notes and records. Second, and supportive IME reports or IE reports. Okay, so the question of how long does an LTD insurer have to respond is a very frequent and common question. I typically tell people that, look, if you've applied, if you've given the insurance company all the information that they've asked you, the medical documentation, whatever it is that they needed, you should be waiting no more than about a month. Even that is a lot, in my opinion. The second question, of course, we get from people is, well, what do we do in the event that the insurance company just drags their feet? Well, what I typically tell people is give them up to a month. And if you're still not getting a response or they're telling you that it's in process, tell them that you are seeking legal advice. Give them a deadline. Tell them, I want to get a response from you by next Friday at 5 p.m. Eastern time, Pacific time, whatever the time is. Give them that deadline and then state in your email, in your written correspondence, that if you do not receive a response, you will take that as a negative, as a declining of your application. So in other words, put their feet to the fire. And at that point, if they haven't given you a response or if it's negative, you should be reaching out to us so we can examine the situation and tell you what your options are. Ultimately, if your doctors say that you do need that help, if you do need to be off on disability, the insurance company must approve your claim and they must pay you. But As to the question as to how long it takes them, it does vary. I've seen situations where people tell me, look, it's been months and months, just like this gentleman here, Peter, who says he's applied in November, where we're now in March. That's 4 months later. That should not take that long. Absolutely not. Again, a few weeks, maybe a month. Beyond that, unless there's a very, very good reason, unless the insurance company is missing key documentation, which I assume Peter has provided already, the insurance company can come back and give the decision. Don't let them drag their feet. Next question here. If you're being treated for impairment, but the treatment will make you unable to work, does that qualify you for LTD? So I don't know what the impairment is, but let's assume for a second that you're dealing with something, whether it's substance abuse or whether it's a neurological issue or whatever the issue is. Let's say that you are suffering, actually, let's use a very frequent example, unfortunately, which is cancer. Let's say you have cancer, you can work with your cancer, but you're undergoing chemotherapy treatments, and those chemotherapy treatments make you unable to work. Yeah, absolutely. If your doctors confirm that you cannot work for any reason, whether it is physical or psychological or a combination of both, you should be applying for disability. And if you get denied, or if the insurance company says there's not enough documentation or any number of reasons, reach out back to us so we can look at the documentation and the denial letter, and we can tell you what your options are. But the fact that you're getting treatments and those treatments are in fact disabling you, it does happen. Keep in mind that in the example I gave of cancer, the underlying issue is in fact cancer. So I don't think the insurance company can delineate the treatments from the actual condition, from the symptom, right? We got to put them together, and we got to say, look, because of the condition, because of the disease, this person is unable to work. Insurance companies, again, they will use every excuse in the book, every reason they can come up with to deny your claim. That does not mean that it holds water. It doesn't mean that they have a legitimate reason to deny your claim, but they'll make you think that they do. And that's why I tell people you have to get legal advice. Let us take a look at it. It doesn't cost anything. Okay, I'll put it out there right now. It doesn't cost anything to get this information and advice from us. There's a question here from somebody on YouTube, from Lee. Can you study full-time while on LTD? If you get OSAP or declare tuition paid on your taxes, do insurance companies have the right to get a copy of your tax returns or somehow find out? All right, so there's a few questions here. Of course, you can study while you're on LTD. That said, again, the insurance company evaluates your claim holistically, or at least they should. And so from their standpoint, they're going to think, well, wait a second, if you can study full-time, can you do a job full-time? And again, I don't know what the facts are of the case here with Lee's situation, but the insurance company is going to try and assess whether or not you are disabled from working. So it does depend. For example, if you're studying full-time, if you want to become a paramedic or a doctor or a carpenter, something that requires you to either be on your feet or just be active, again, the question becomes, well, should you not be able to then do work, right? Should you actually be on LTD? So keep that in mind. The insurance company will draw inferences, and they may deny your claim, reject your claim, or stop your claim just based on their assessment and inference from what it is you're undergoing. So it's not that because you're studying, they're going to stop your claim. It's because of the conclusions they draw from the fact that you're able to study full-time. Now, you're asking if you get OSAP or declare tuition paid on taxes, do the insurance companies have a right to a copy of your tax returns? I'm often quite resistant to giving insurance companies financial information. They do have the right to know if you are earning income elsewhere. It does bear relevance to your disability claim and whether or not you are working, in fact, whether in fact you're able to earn income. But I am very, very careful with the information that I allow my clients to disclose to the insurance company. And frankly, I keep this on a very tight leash. I don't want to give the insurance company more information that they are allowed to get by law. Peter's asking, I have a phone interview in January and they said that there is insufficient medicals and keep requesting more. Okay. All right. I'm going to break this down. So first of all, you said you have a phone interview, that they want to understand a bit more about your situation. Well, when an insurance company says that we have insufficient medicals or medical documentation to prove your disability, to me, that's code word for we don't like what we're seeing. Rarely have I seen claims where a person is in fact disabled, provide that documentation from the doctors to the insurance company, and the insurance company coming back saying that's insufficient. And when I go after the insurance company does a reverse course. And what I mean by that is that insurance companies notoriously throw excuses and reasons for denial of claims. and they'll try and shake you off claim by saying there's just insufficient medical documentation. Well, what does that mean? What does that mean, insufficient? If your doctors or whoever's treating you is telling the insurance company in writing that you're disabled and here's why, here are the symptoms, here are the prognosis if there is one, here is the diagnosis if there is one. There's not always a diagnosis. Sometimes the diagnosis is elusive. But as long as your doctor or doctors are saying to the insurance company that you, Peter, are unable to work because of so-and-so, the insurance company should approve your claim. And if they're not, you may have a legal claim against them. I say may because I want to see, obviously, what it is that you've given them. Now, you've mentioned here, I see another follow-up here. I was involved in an MVA, motor vehicle accident, and my treatment plan believes I'm catastrophic for psychological, cognitive, and CPA. Okay. First of all, if you're catastrophic, you're going to be potentially having access to significant accident benefits. So we don't just deal with disability claims. We deal with personal injury matters, serious accidents, serious falls, any form of injury or demand for compensation from insurance companies. This is what we have expertise in. It's what we specialize in. And so, Peter, I can tell you right now, not only are you potentially entitled to significant benefits from your own insurance company, which I'm sure you're getting, but the insurance company, if you're being assessed for a catastrophic designation, then I can't imagine how your LTD insurer denies you LTD coverage. I simply can't. To me, it's a no-brainer. And the fact I think you've mentioned, you may have been waiting for this since November. Something is off here. Something is wrong. I don't know if you are doing it yourself or you have somebody helping you, but feel free to reach out to me after this Facebook Live. I'll be more than happy to speak with you or have somebody on my team review everything for you, tell you exactly what your options are, what's going on, answer all your questions, again, for free. Okay, it doesn't cost a cent. I want to make sure you understand what your rights are. I want to make sure that you understand, if the insurance company is doing something wrong, which appears to me like they may be doing here, I want to make sure that you understand what recourse you have. A question here from Lee. I'm on LTD. Can I study full? Okay, so you had asked for that. Peter, okay, I have another question. I received 7 days AC, RSW weekly. Okay, so I think I answered your question, Peter. I think that if you have applied for LTD back in November and you're still not getting it, there is a problem here, and I'd like to understand what it is so that we can help you. Okay, Laura Lee H. Sorry, Layla M. We have a lot of questions here. If I decide to start selling knitting and crochet items from home, but I'm on LTD, is this something my insurer will have a problem with? Yes. So keep in mind, Layla, I don't know what is the nature of your disability, but first of all, if you're earning income, the insurance company needs to be aware of this. You have to be upfront with them. Very, very important. Because if they find out later, I mean, leaving aside the ethical and moral issues here, which I think we have to be aware of, clearly, if the insurance company finds out, they're going to cut you off. They're going to say that you lied, you didn't disclose this to them. So it's really important for you to make sure that you are upfront with them. And listen, maybe what you're doing is not going to move the needle. Maybe we're talking about a little bit of money here and there. The insurance company is not going to infer from that you can go back to your job, whatever your job was before. But it is important that you disclose that to the insurance company, again, because you do have an obligation for full disclosure and to advise the insurance company, if you're an LTD, that you are in fact earning income and that you are able to do certain things. Keep in mind also that if you are talking to your doctors about this, there's a good chance that this information has made it or will make it into their clinical notes and records when they make notes. And so when the insurance company gets a copy of those, they may see that as well. So again, you want to make sure that you are truthful, and yes, the insurance company is going to want to know about this. Laura Lee, with mental health issues, which might be work-related, would you file a WSIB claim first or disability claim or both? Fantastic questions, Laura Lee. Okay, so first of all, work-related issues. I'm going to try and break this down here because oftentimes people will be on disability or will apply for short-term or long-term disability because of work-related stresses, work-related issues that impact their mental health. Now, in some instances, the insurance company will come back and will tell you that they're denying your application or cutting you off, often it's a denial, on the basis that this is in fact something that is work-related. I have a colleague, a partner in my firm, who says that long-term disability is not bad boss insurance. And what he tries to say, and when he says that, is that the insurance company will recoil if you're asking them to pay you because you're having difficulty at work, because if it's a toxic work environment, or you're having some issues with your boss or colleagues. That said, that's what we call a situational disability, meaning that it's specific to the situation at work. If we were to put you in a different environment and you'd be able to function, you'd be able to do your work, well, if that's the case, then your insurance company may not have an obligation to pay you. Okay. However, if your mental health issues arose from a work environment, however, now they become generalized, meaning that it doesn't matter anymore whether you're at your place of work where this originated or in a different place of work, somewhere else. The fact is that now you're depressed or you're anxious. You simply can't work no matter where it is. That's called generalized situational disability, which means that the insurance company should pay you. As to the question of WSIB or LTD, you can certainly apply to both. You won't be able to get both. If you get WSIB, which is workers' compensation, your insurance company will likely not pay you because those two benefits overlap, they don't stack. I will tell you, however, that if you had a choice, if it was possible to get one or the other, you'd want to go with your disability insurer, with your LTD insurer, not WSIB. I don't deal with WSIB, but I can tell you I've heard enough horror stories about WSIB and about dealing with them. There's very few lawyers and paralegals who deal with WSIB for various reasons. So people who typically go through that system end up having many, many more issues. And it's not simple to tackle those just from a governmental legislative standpoint. I won't be able to help you. But for LTD, yes, we would be able to help you. So if you had an option to choose one or the other, I would definitely go with LTD. Question here from YouTube. I'm currently on LTD while working to get my diabetes under control. After going to fill a prescription, I found out that my health benefits have been cut off. Is my employer allowed to just cut me off? Do I have any coverage through my disability benefits? That's an excellent question. Common question I get is, if I can't work because of my diabetes or because of whatever other illness I have, will I be covered for LTD? The answer is yes, so long as you're not able to work because of that disability. But the question here is what happens, it's an employment matter here. The employer is the one who cut off the benefits. So I will tell you right now, full disclosure, I'm not an employment lawyer, but there are quite a few employment lawyers who work at my firm. And in fact, we have a Q&A coming up on March 6th at 1 p.m. Mountain Time with Haley Auger, one of our employment lawyers. So stay tuned for that. But you can feel free to reach out to me or to somebody at the firm or in my group, and I'll put you in touch with the right person. I don't know the answer as to whether or not your employer is allowed to cut off your benefits, but I will tell you this, that there is a general proposition in employment law, which is that if the employer stops something or changes the character or the nature of your employment relationship, and that could be vis-a-vis compensation, maybe benefits or something else, potentially they are on the hook for that. In other words, they potentially may have constructively dismissed you. But what I would urge you to do is to reach out to me or a member of my team afterwards, and I can put you in touch with the right person to answer your question. You will not get this kind of coverage for medications, for example, or health benefits outside of LTD through the LTD policy, okay? Unless the LTD policy provides for that. LTD is LTD, long-term disability, short-term disability. However, if you have group health benefits, those group health benefits may include prescription medication, some amount for physiotherapy, for massage, for long-term disability, etc. So again, if the question is, what do I do with my employer who's cut off my benefits because I'm on LTD? That's a question for our employment group, and I'll be more than happy to put you in touch with somebody on our employment group to answer that question. Okay. How far from your original vocation does doing anything have to be for it not to conflict with your LTD? Having a brain injury means I can't do a lot of things and nowhere near to what my old job was. That's an excellent question. So there's a few ways to tackle this question, and I want to make sure that I'm absolutely clear with the answer here. In many instances, the insurance company will stop your benefits after paying you for about 2 years because they'll be arguing that you can do some other vocation, you can do some other job, some other occupation for which you are suited for. Now, you're asking, how far from your original vocation does anything have to be for you to be cut off LTD or for them to, take issue with? Well, in that situation, that 2 year mark, where the test changes for you to get LTD from being able to do your occupation or any other occupation, it has to be something for which you are trained for or have experience or education in. Okay. If you're a carpenter, you've been a carpenter for 20 years. If you're an engineer, been an engineer for 20 years, or a nurse or whatever it is, the insurance company can't come to you and say, look, we want you to do something that is completely outside of any sphere of knowledge that you may have, either by training, education, or experience. Those are the three words: training, education, or experience. There's another way to look at it, Leila, which is this. Can you earn in another job the amount that you're currently getting from your LTD insurer, 60 or 65 or 66% of your pre-disability income? If the answer is yes, that you can do another job where you are in fact getting or able to get that amount of money, that commensurate income, 60, 65, 66% of your income, the insurance company may have grounds to cut off your benefits or to tell you that they're not going to pay you. But there's a lot of gray area here. It really does depend. It depends on the facts of the case. It depends, are you working full-time or not? Do you need to work with modified duties or not? What kind of job are you doing? Jurisdiction. It really does depend. I mean, I hate to say that I can't give you a precise answer, but it is very fact-specific. And it's important that to be fact-specific because insurance companies often apply a one-size-fits-all approach to these circumstances, and your situation, Leila, could be very different than somebody else, and George's or from Luke's or from somebody else's. So to answer your question, if you can earn income and that income rises to approximately what you're getting from your LTD insurer, you're likely going to have a problem with your long-term disability insurer. You may still have a problem even if you earn 25% of what they're paying you, because they may still tell you that, look, you can do something else, right? They can draw an inference from that maybe you can do more. So you just have to be very careful with earning money or doing work while on disability, because the insurance company will often use that, weaponize that against you. Again, I'm speaking as a lawyer who handles these kinds of claims and sees these. Insurance companies, unfortunately, are not there for you. They're there for themselves. Whether that's bad or good is a different story, okay? I don't like it, obviously, but that's the system that we have. That's how it's structured. Insurance companies are there to make a profit. And if they can find a reason, any reason to stop paying you or to force you to quit your disability, well, then trust me, they will engage in that. They will do it. Okay, question here from Yasir. I have been waiting for almost a year for my disability claim to be approved. Wow, but I'm running out of options. If I have to return to work on modified duties so that I can pay my bills, will this impact my claim? You should not have waited or have to wait for that long. The insurance company is absolutely wrong to make you wait that long. I don't know, Yasir, if you've been here since the beginning, but somebody else asked me, how long do you have to wait for an answer? I tell people, look, if you're waiting for more than a month, that's bad news. It means the insurance company is dragging their feet, unless they're asking you for documentation which they truly need. And sometimes it's true that they need this documentation because they don't have enough to go on. But typically I find that they have enough to go on. They just try to drag their feet and try to make you give up on your claim. I tell people that if a month passes by and you've given them everything they wanted, give them a deadline. Tell them that they have until so-and-so date by so-and-so time, at which point, if you get no response, any response other than a yes or a no, you're going to treat that as a no. And then you're going to seek legal advice. That's when you should come to us, and we can help you, obviously, with that. We can review everything for you and tell you what your options are. But the reality is, Yasir, is that if you are disabled and the insurance company has been dragging their feet for that long, you should be taking action right now, and we can help you do that. Now, you are asking something that's interesting. You're saying, you got bills like everyone else. What if you return to modified duties because you have to pay your bills? It's a double-edged sword. Obviously, you need money. You need to be able to survive. Maybe you have kids, maybe you have a mortgage, whatever the situation is. But here's the problem. As soon as you go back to work, you've made the case for the insurance company that you, in fact, can work. Even if it's on modified duties, the insurance company will then reposition its position and say to you, look, If you can work on modified duties and earn the money, even if it's close to the amount you were earning before, well, then we don't have to pay you anything. And if the employer gives you a hard time, guess what? You have an employment issue on your hands, not a disability issue. So oftentimes insurance companies will rely on that. They will try to squeeze you, right? This is where people are stuck between a rock and a hard place, the insurance company and the employer. The insurer says, we're not going to pay you. It's an employment issue. The employer says, we don't have the ability to give you modified duties, modified hours, accommodate you. Go to the insurance company. Well, is it a failure to accommodate problem, or is it a disability denial problem? Again, this is why at our firm, because we do both disability matters and employment matters, we can advise you and kind of deal with both issues. But the reality is, Yasir, you're asking me, is it going to impact your LTD claim or your application if you go back to work on modified duties? I think it will. I think the insurance company will draw a conclusion from that you're able to work, and therefore, to the extent that the employer is giving you a hard time, it's an employment matter, not a disability matter, and they'll deny your claim. But again, feel free to reach out to me after the Facebook Live with more specific questions. Another question: if you're an LTD and do a lot of severance on an investment property, I assume that what you mean is that you're getting money from an investment property and sell it. Is that capital gain an issue for your insurance company? Do you need to report capital gains? So let me go back to the way that we analyze these kinds of issues in general, because that's going to inform you, Lee, not just about the question you're having here, but just generally how to deal with income that you are receiving from any source. LTD policies typically contain provisions that stipulate that if you are earning income from any source, that the insurance company, first of all, should know about it, and number two, that it may be put against or deducted from whatever LTD amounts the insurance company has to pay you. Now, does that apply to capital gains? Does that apply to rental income? Does that apply to inheritance? I get those kind of questions all the time. The reality is this: if you have passive income, or if you have investments, and it's not your job, it's just something you're selling off in order to be able to survive because you need to make ends meet, you need to pay the mortgage, I don't think that that's going to get captured under the LTD policy. That's not to say that the insurance companies are going to come back and say that it does, but I don't care what the insurance company says. I care what I see in the policy. Many times an insurance company tries to deduct certain things from the payments that they owe individuals. So for example, I've had people come to me saying, I'm getting passive income from a rental property, but really I used to work as an engineer and now I'm disabled and I can't work. And the insurance company says that because I'm getting this money, this passive income, that is offset against the disability payments they're paying me. No, it's not offset. And in fact, when we go to the policy and we review the provision, the income provision, the offset provisions, unless it specifically stipulates that something like passive income should be offset, then no, it should not. And while we're on the topic, it's very important for any one of you here who is on LTD or considering to be on LTD, get a copy of your policy. And if the insurance company is asking you to do something or is giving you their position on something, such as income, for example, or deductions or offsets, you can ask your adjuster or the insurance company, show me where in the policy it says you can do that. And if the insurance company points you to the provision in the policy that they say allows them to do what they're telling you that they're going to do, and you read that provision, and that provision has a different interpretation, that you're seeing that provision differently, there is a principle in law, a doctrine in law. I'll throw some Latin at you. It's called contra preferentum. What it means is that if in an insurance contract you have a provision, and that provision can be interpreted in different ways, reasonable ways. The insurance company interprets in one way that's favorable to them. You, as a regular person, interpret that provision in a way that is beneficial to you, and both are reasonable interpretations. If this ever went to court, a judge would side with you. Because the principle of contra preferentum in insurance contracts stipulate that if there's an ambiguity with respect to an insurance contract, any provision, it will be interpreted against the insurance company. That's just the way it is. So again, if the insurance company in any scenario here is telling you something and you disagree with that and you tell them, show me where in the policy it says X and Y, and the insurance company here says, this is where it says that, and you read that same provision and it means something else to you, and your interpretation, let's assume, is reasonable, well, then it's your interpretation that should govern here. I know it seems strange, but that's in fact the case. And if there's a problem with that, again, this is where we come in and we can help you. And we can tell you if we think your interpretation is reasonable or not. We're running out of time here, but I'm going to just take a few more questions here. How would you suggest dealing with a rude and unhelpful insurance rep when working through a claim from LTD? I'm in early stages of my application, but the person I'm speaking with is terrible. That is terrible and completely inappropriate, unprofessional. I think that you need to confirm in writing to the insurance company, to that adjuster or whoever it is, that they're being rude, that they're not being helpful to you, that they're increasing your anxiety, whatever the situation is. I can tell you right now that if they're in fact doing that and you confirm that in writing to them, that could be grounds down the road for a claim against the insurance company, particularly if they deny your claim, for special damages, for punishment against the insurance company. I've seen those situations happen where adjusters or claim reps have been very rude. They have zero right to be rude. And I can tell you, you can ask for someone else. You can speak to a manager. But again, if you're still having those difficulties, it's very fact specific. Just contact me. Again, it doesn't cost anything, whether you're speaking with me or somebody on my team will be able to tell you. We've dealt with these situations time and time again. I hate it when the insurance company does this. They have no right to do it, and we've hammered them before on those situations. Okay. Again, I know that we're out of time here, but I'm going to take one more. The investigator scared me, and the caseworker accused me about malingering to justify surveillance. Surveillance did prove I am honest, but they really did everything to cut me off. Okay. So you're saying they did everything to cut you off. If you're cut off, please reach out to me. We're going to help you. Okay. Surveillance, I can tell you unequivocally that in the vast majority of time when insurance companies do surveillance and cut people off because of it, when I look at the surveillance, it either shows exactly the opposite of what the insurance company says, or it doesn't show anything. It's just used to gaslight the individual. So again, don't be scared of these insurance companies. I'm telling you as somebody who used to work for them, okay? It is a mirage. They do not have the power that you think that they do. And keep in mind something else. The one thing that insurance companies, again, from experience, one thing insurance companies hate more than paying claims is paying their lawyers to defend claims that they know they're going to have to pay out. But they also know that most people will give up. So if you give up without seeking legal advice, you're potentially giving the insurance company a lot of money that's owed to you and not to them. It's your prerogative, it's your choice, but keep that in mind. And I've seen this, again, having worked for insurance companies in the past, you don't have to do it. You have a lot of options. They're not above the law. We force them to pay time and time again. But listen, if the insurance company is correct, I'll tell you that they're correct. But if they're not correct, as happens quite often, I will tell you they're not correct. They're wrong. They've cut you off illegally. They're dragging their feet. I am telling you, we can help you. Just reach out. We're out of time, unfortunately. I'm sorry. We do these Facebook Lives. Please make sure that you follow us. We do have an employment law Q&A for those having questions about their employment, particularly now with what's happening in the States and the tariffs and all that. You may have questions. Haley Auger, a lawyer in our Calgary office, is going to be speaking on March 6th on Thursday, tomorrow at 1 p.m. Mountain Time. And again, if you need anything, any questions you may have about long-term disability, injury law, employment law, please reach out to us, okay? We're here to educate and to help you navigate these claims. They can be very, very difficult. They can be very overwhelming, but we are on your side. We're in your corner. We're going to help. Thank you.